Good afternoon, everyone. Thank you so much for joining us today for our last webinar of this biennium. Just a reminder that this webinar and this CEU can only be used in the current biennium. The next biennium does start on July 1st. Just a reminder, you can ask a question during the webinar, type those into the question box, and at the end of the webinar, Mike will be happy to answer them. Also, we do have over 500 people on this webinar, so please be patient as we get these credits posted to your portal and get the letters out. We know a lot of you are anxiously wanting to hand in your paperwork to the Bureau, so we will do our best to get these in ASAP, but please give us a few days for that. And as you saw in the commercials before this webinar went live, there is a two-step process in order to get your credit. We've been reminding everyone because there are still people who are not pre-registering for these webinars. You definitely need to pre-register through your portal, and then the day of, you register through the GoToWebinar, where one person can list everybody. But prior to that, everyone does need to be pre-registered in your portal. As always, if you get dropped during this call, and you can't get on or you have any problems, please give us a call or email us immediately. Okay, I think that's it for announcements. At this time, I'd like to welcome our Executive Director, Mike Lunati, to do our presentation today. Welcome, Mike.
Thanks, Kelly. Thank you, everybody, for joining us today. We always know that our law sessions usually attract a lot of people, and since we are getting close to the end of the biennium, we're hoping that this will help you get to where you need to be for your registrations. Today we are going to be talking about Preneed Law in New York State. Quick disclaimer, because we're doing law, and I think I'm just one of those people as a lawyer, I put my lawyer hat on, and we're going to be going through the statute. Obviously, words are very important. So the slides that you're going to see contain a lot of things I normally would just say out loud. And again, I feel it's important for you to see as much of the wording as much as hear the relevant information on this topic. Okay, we're going to get started. We will be going section by section through the General Business Law 453, which is New York's Preneed Law statute. The law was enacted in 1993, and it has been amended 5 times since. I will touch on a few of the amendments, and I will also touch on a few other relevant laws and regulation as we go through the presentation. So let's get started. All right. Maybe not. There we go. So let's. Oh, what is going on? Okay. So, quick overview. When you establish a pre-need, it is, as I'm sure you all know, similar to an at-need agreement. You are creating a contract between you and the purchaser for funeral service for a beneficiary upon their death through a pre-funded account. The bullet points on the top half of this slide break each of the elements out individually. So I'm not going to go through it all, but you also know that the purchaser can also be the beneficiary, doesn't have to be, but those are the elements stated in the law for what actually creates and makes an agreement a pre-need agreement. And as I just mentioned, the main statute overseeing pre-need law in New York is General Business Law Section 453. The other relevant law and regulation is Public Health Law Sections 3442 and 3450, as well as Health Regulation Part 7712, which I will touch on as we go through. So other thing to note as I start working my way through this, you'll see at the top I have the actual paragraph numbers in parentheses next to the section number. So I'm going to go through the statute in numerical order, section by section. If you're like me, it's going to seem like things are maybe being addressed out of order. We will cover it all by the time we're done, so no worries there, but just if it seems a little disjointed, that would be one of the reasons why. But the way the law is written, the first section of the general business law covers deposits. So what does it say about deposits? First and foremost, the money continues to belong to the person who opens up the account, the purchaser. This is unlike insurance premiums where the premium dollars paid become the insurance company funds upon payment of the premium. One of the major distinctions between a trust and insurance. Secondly, any deposits must be held in trust for the person by the person who receives it. So in trust does not mean it has to be held in a trust account. This often becomes very confusing to folks. Being held in trust is really relates to the last part of that sentence, which says person who receives it. So what really is happening is you're creating a fiduciary relationship. So the funeral director who receives the money from the customer is the fiduciary who is responsible for holding that money in trust, taking care of that money, since the money still belongs to the person. When you deposit the money, it must be placed in an interest-bearing account. The intent and the hope is that the interest that is earned keeps pace with any increased cost at the funeral home so that at the time of need, there is enough money to cover what the current costs are. It's never been intended to be an investment vehicle like a 401k or other retirement vehicles. And the administrators or the financial institutions you're hoping that it's going to keep pace as best as it can. When you have the money in those interest-bearing accounts, the law states very clearly that the interest earned must be accrued daily and must be credited monthly. What that means is on the back end is the accrual. So the customer on a daily basis is not going to see necessarily the amount that they are earning in interest. Every month, however, if somebody was looking at their account balance, there should be on their statements a showing of how much interest was earned that month. You have to give them an annual statements, which we'll talk about, showing things like the amount of interest earned over the course of the year. But the law does say that you have to see it every month. So if no matter where you have your pre-need funds and accounts, make sure that that's happening. Otherwise, there's a potential violation of the law. Some of the timing issues, some other details. When do you have to deposit the money in an interest-bearing account? It has to be done within 10 business days of receipt. Where are you allowed to deposit those funds? It can be in a bank, a savings and loan, a credit union, or a trust company. If it's in a financial institution, meaning the bank, savings and loan, or credit union, then those accounts that it's deposited in have to be earning the prevailing rate of interest, meaning it can't be in an interest rate lower than other type of accounts similar to the one you're using at the financial institution. If it's in a trust company, then it has to be invested in an instrument backed by the U.S. government, for example, a certificate of deposit. When you put the money in, is there any particular way on how you have to deposit it? There is. The money cannot be commingled with other funeral firm money. So if you're using a bank, for example, and you're using the same bank that your funeral firm uses for its operating expenses, you can't put your pre-need customer accounts in that same account. You have to open up a new account specifically for pre-need. It does not mean you have to open an individual pre-need account for every single customer you have a pre-need for. You can commingle the money, all the pre-need monies of all your customers together, which is good news because it means you can generally get a higher rate of higher interest rate earned because it's a higher balance. But you can't commingle it with other funeral firm monies. How long? Well, that's basically dependent on the circumstances, right? But the money must stay on deposit in the interest-bearing account until the services and merchandise are provided, the at-need time, unless repaid sooner. We'll get into the details of repaid sooner, but that generally means if it's a revocable account, it'll be a refund back to the consumer. The next portion of this section 1 covers the statements that must be provided. And as we'll see, statements are required at different times based on specific actions. There's basically 4 events that trigger the need to provide a notice prior to the provision of services under the agreement. So let's walk through those. The first one is upon receipt of money. So when you receive the money, within 30 business days of receipt of that money, you have to provide written notice to the consumer, letting them know the name of the institution where you put their money. Second time is annually. It's the same as the notice above, but it also must include the annual interest earned. So Every year you have to give a notice to the consumer, again, letting them know where the money is and how much they've earned in interest. A third triggering event is if you change the depository institution. So if you change from bank A to bank B, for example, you would have to provide written notice, again, within 30 days, but this time it's within 30 days of the change, and you would have to give them the name of the new institution that you are using and where their money is deposited. And the last, or fourth, is simply by a request of the consumer. At any point in time, if the consumer asks for information about their account status, again, within 30 days, this time of their request, you must provide written notice that identifies where the money is, the amount that is on deposit, the current balance, and the interest that has been earned on the account. Once you've provided the services and merchandise, you must also provide another type of statement at the end. And that one is going to itemize the services and merchandise you actually provided, how much that cost was, and how you disposed of the money in the account. Obviously, if the money was used to cover all the service and merchandise, you're going to talk about that. If there's overages, we'll talk about that later, but you're going to have to explain what happens to the other amounts. The last situation requiring a statement is to address any complaints. So if there is a verbal or written complaint that's filed, or an inspector, and for purposes of the law, an inspector really means a representative from the Bureau of Funeral Directing or the Department of Health. And if there's a complaint filed or this inspector has reason to believe there's been a violation, then you have to have copies of the statements and records available for inspection. Those inspections can take place at any time during normal business hours, and they can be copied by the Bureau of Funeral Directing. The law next addresses irrevocable account basics. So starts with, and we should go through, what is an irrevocable account? So under the law, an irrevocable account is an account for any person who's an applicant or recipient of supplemental Social Security income or Medicaid. If they are, then they must have their agreement, or if they're opening an agreement for a permissible family member, that agreement must be placed in an irrevocable trust. So what can the purchaser of an irrevocable account do? Well, that person can choose their funeral home or funeral director. They have the ability to change to another funeral home or director, either inside New York State or outside of New York State. They can change their selections, pre-need or at-need, subject to certain restrictions. So if you're making changes, the new items must be of equal or lesser value. And if there's an overage in the account, the person cannot use it to cover additional service or merchandise. So that basically means that at the time, at need, if everything was selected and it earned enough interest that it is now more than you need, or they've made some changes that were of lesser value, so there's more that you need, you can't then at the end legally add new product, new service or merchandise to use up the amount that's in the account. If a consumer seeks one of these changes, that change under the law must be carried out within 10 business days of the request. I mentioned at the onset that this law was amended several times. One amendment was made in 2011, and that was to address the accounts for family members that I just mentioned. So that change requires that an account set up for a family member by a recipient of Medicaid or SSI must also be irrevocable. And the reason is that the value of all these accounts are not considered a countable resource. So that helps with their spend down when they're trying to make sure that they're eligible for Medicaid. So I'm sure you're much more aware of this practically than I am, and you've come across this where you have a family member coming in who's looking to spend down, and they might open an account for themselves, and they look to open an account for a family member. So who are the permissible family members that they can open accounts for? The list is here for you. It's a spouse, a child, a stepchild, sibling, or parent, or the spouses of children and siblings. So again, if you have 4 kids, it says children, you could open it for all 4 of your kids. So it is plural in each of those categories. One important thing to keep in mind as you're deciding they're deciding what they'd like to include in there is that there is a Department of Health directive that is in writing out there from years ago that says you should not include food, lodging, or transportation of family, friends, or guests in a pre-need agreement. The reason is it could be deemed an quote unquote uncompensated transfer, and it could delay the ability to receive benefits. So that was the rationale that the Bureau or the Department of Health gave for not including those specific items. So now we're going to slide over to section 2, which covers refunds and fees. So the general rule here is that the amounts paid along with the interest earned has to be repaid up on demand at any time prior to delivery of service and merchandise, right? So it's a revocable or an irrevocable account. If it's irrevocable, you can't refund or repay. If it's revocable, then upon demand, you have to give that back. And if it's irrevocable, and we'll go through this again and later on, but the rule is any excess funds must be forwarded to the local DSS office in the county where the person resided at the time of their death. Also, you are not entitled to charge an administrative, consultation, or other fee against the consumer who pre-funds their agreement in connection with the planning of the agreement. So when they come in and they want to talk to you about setting up the agreement, they're planning all of this, you can't have any type of fee associated with doing this. However, under the law, you can assess a fee for administration of the account, and that can be up to 75 basis points or 0.75%. Moving on to section 3 of the law, this section sets forth the requirements for a pre-need agreement. The requirements are consistent with general contract law requirements for typical service contracts. So this is the first of 4 slides of the requirements that we're going to go through. So specifically, the law requires that a pre-need agreement be in writing. It identify all the monies paid or to be paid at a later date. So that's if you're going to pay in installments. It has to identify any fees paid to the administrator. I just mentioned you could have up to 75 basis points paid. So if there is going to be that administrative fee, you have to disclose it in the agreement. You have to notify the consumer of the right to their annual statement, the statement provision I talked about earlier. You also have to let them know if it's a revocable agreement that they do have a right to demand a refund. You also have to identify the provider for each merchandise of or service selected. And then lastly, you have to fully describe each item of merchandise or each service selected. The agreement must also describe each party's obligations. So insert and its obligations in certain circumstances. So if the services and/or merchandise cannot be provided as agreed when needed, then you have to describe what's going to happen. Just by way of example, for pre-planned clients, you would probably remember that pre-planned agreement says you may substitute a comparable service or merchandise. So if I've selected something very specific, it's not going to be available potentially. You might not know that at the time, but you need to let someone know that they can pick something comparable if that's what you're going to, how you're going to describe it or address it. If you're doing something else, you have to describe that. Another thing you must describe and explain is if the cost of the service or merchandise winds up exceeding the amount that's in the account, then you need to explain that. Again, just by way of example, pre-planned contract says the purchaser is responsible for paying the difference. So again, whether that actually happens at need or you waive that, that's up to the funeral home, but in the contract, you must have that described what will happen. Another situation is if the amount paid plus the interest accrued exceeds the cost of the service and merchandise. So now you have more, you have an overage, you have more money in the account than you need. Under the law, if this winds up being a revocable account, then it actually states the excess must be returned to the person who paid it, if they're the purchaser and they're still alive, or to the estate if the purchaser happened to also be the beneficiary. I already mentioned this under the revocable, but if it's an irrevocable, then the agreement must describe the fact that any overage would be forwarded to the county DSS office. Continuing on with the requirements, the law defaults to guaranteed pricing. So this is actually the way the law states it in these quotes. If the agreement does not provide to the contrary, then the then the services and merchandise must be provided for no more than the price stated therein. So if pricing is not going to be guaranteed by your funeral home, you need to be crystal clear about that. Again, just because it's easy to use as an example, if you're a pre-plan client, you know that pre-plan has guaranteed and non-guaranteed versions of the agreement for each type of account. So there's all of that set up, and it's something that you need to keep in mind. It's going to default to guaranteed. So if you don't mean to guarantee it, you got to make sure you're letting the consumer know this is not guaranteed pricing. If you're going to guarantee a portion and not other portions like cash advances, you need to make that clear as well. The law also requires that you have an alternate person. Now, I shouldn't say it that way. You must make it available to the purchaser to have an alternate person named. What is an alternate person? An alternate person is somebody who's not living at the purchaser's address, who they would designate to receive the required notices if you can't contact the purchaser. And that's those, for example, annual statements. If the purchaser declines in writing to specify an alternate person, then that's their choice. They don't have to, but the agreement that you're using must include a space that allows for the purchaser to select an alternate person and to describe what the alternate person is being designated for, which is described here. So now, again, this is where it starts to get disjointed. They kind of bounce between irrevocable and revocable as it relates to certain things. So now I want to just cover with you in the same section 3, some specific wording that is required to be included in every irrevocable agreement. So I'm not going to read all the small type, but every single one of these words that you see there in the smaller type on the slide have to be included in an irrevocable agreement, and it must be written exactly this way in at least 12-point type. And basic elements of this disclosure are, it's stating that the law requires the agreement be irrevocable for SSI and Medicaid applicants and recipients, that this applies whether the agreement is for you, the purchaser, or a family member, principal family member that we described. If the money is left over, that it's going to go to the county, that you can change your choice of a funeral home at any time, and that if the agreement is for a family member, after the purchaser dies, the family member can change their choice of funeral home. So pretty much everything I just went through in the other slides is consolidated and placed in this disclosure that must be included in the agreement. The disclosure must also be in any marketing materials that you are using when you are talking about the irrevocable nature of specific accounts. The next section of the law explains what's required upon the sale, transfer, or closing of the funeral home or the transfer of the accounts. So I like to look at this in terms of the who, what, and when of the required notices. So starting at the top there, who do you have to give this notice to? So this is a situation where you're going to sell or transfer your business or the account. So you're selling your funeral home, you're going to move the pre-needs. You're going to just sell your book of business of pre-needs. This is when these notice requirements kick in. So you would have to give that notice to every person who has an account. Both the seller and the purchaser must provide notice. You can both pen a letter together and send one notice together to the consumer. That notice has to go out within 30 days of the sale or transfer of the accounts. It must be in writing, and it must include the name and address of both the new and former funeral director, owner, or funeral home. Copies must also, upon request, be provided to and available to the agency or official with jurisdiction, meaning the Department of Health, the Department of State, because this is under general business law, or the Bureau, again, under normal business hours, and they are entitled to copy it. Just as a side note, if you are closing your funeral home, you should also notify the Bureau of Funeral Directing and your depository institution of the closure and the disposition of the assets. Continuing with this section, it also speaks specifically to your liability and what the transferring funeral home must do. So first, let's look at the liability. The law states that a transferee, meaning the person accepting or getting the accounts, is strictly liable for compliance with all provisions of the general business law. So I highlighted strictly because when you're talking about the law and you say strict liability's meaning is that it doesn't matter what you have from the transferor or what you don't have from the transferring firm. It doesn't even matter if you actually received the money or had knowledge of the existence of the pre-need agreements. You are strictly liable, and that's why it's so important to make sure you get an accounting of everything that must be provided. So the law also says that the firm or the person transferring, the transferor, has to provide an accounting of all the money being transferred. And included in that are the name and addresses of the people, the amount and location of all the monies, meaning where the deposit's located, and the name and addresses of the persons who have received refunds and the refund amount. It's extremely important that the transferee, meaning the firm taking on this responsibility and taking the accounts, gets this information, because as I said, even if you can't come back later and when someone says, "Where's my money?" you say, "Well, I didn't even know. I never got this one." You are strictly liable. Also, if you were to just cease operations as opposed to transferring money, closing your funeral home up, then within 30 days, you have to repay everything to the purchaser, again, except if it's irrevocable. If it's irrevocable, then the person or the customers need to know that they should transfer their funds to another funeral home. Again, just because they chose you and you're now closing up your doors, irrevocable is irrevocable, and you can't get your money back. The only option that the purchaser has at that point is choosing another funeral home. And again, if there's a closure, all of the documents and statements must be available for inspection during normal business hours. And that's pretty much a common theme you're going to see throughout this whole section of law. The next two sections of law, 6 and 7, deal with violations of the law. So I'm just going to walk briefly through each of them. The first several on the top half, 1, 2, 3, 4, are the violations. So what are violations? If you knowingly and willfully fail to deposit money or keep sums on deposit, that's a misdemeanor. So knowing and willfully means I wasn't negligent, I didn't make a mistake. It means I intended and purposefully did not deposit the money. If you fail to provide the required notices, then that's a violation. If you fail to repay a consumer upon demand without a valid legal reason, like for example, it's an irrevocable account, that's a valid legal reason, that would be a misdemeanor. If you knowingly and willfully misappropriate money for a use not authorized under the general business law, it's a misdemeanor. What does that mean? It means misappropriating means you can't put it in with your funeral home accounts. Remember I said you can't commingle. So money cannot be deposited in your funeral home business account. That would be commingling. They have to be segregated. If you don't do that, you could be subject to a misdemeanor. It also goes on to say that the Attorney General can issue injunctions or order restitution, and the penalties can be up to $1,000 per violation. The next section of law covers the record retention requirements. The general rule is hold on to copies of your agreements, notices for 4 years after performing the services, or 4 years after returning funds on a revocable account, or 4 years after the sale, transfer, or cessation of operations. So basically the general rule is hold on to any pre-need related documents, agreements, notices, any other record you have for 4 years after the triggering event. That is the best way to ensure that you are covered. The last thing that the JBL covers are the dormant and abandoned accounts and the annual audit requirements. So what are the rules here? Rules apply to both revocable and irrevocable account. What's an abandoned account? An abandoned account an account is deemed abandoned on the later of 3 years after the date of death. Now again, I should just point out, abandoned means the money's still sitting there and no one's claimed it. So a person's died, it's 3 years later, and no one's looked to withdraw the money and claim the funds for service or any other reason. So 3 years after the date of death, or 1 year after the pre-need administrator has determined the beneficiary has died, if the death occurred less than 2 years prior to that determination. That's a lot of words. What does that really mean? It just means that if it's less than 3 years, if it's more than 3 years after the death, then it's just 3 years after the death. So this other provision is it's 1 year after, but 2 years less. So because it's otherwise it's longer than 3 years, and you're back to number one. The bottom line is, unless you're your own administrator, you don't have to worry about that. But again, I just want to make sure I'm covering everything that the law says. The administrator has to make reasonable attempts using state and federal resources to determine if the person has died. There is a master death registry list that is checked on a regular basis, and you can check to see if someone's died. So bottom line on this is, unless you're administering your own pre-need agreements in-house, the last several sections of the law will be handled by your administrator, meaning your trust administrator or your financial institution. But since you're the one hiring them, you should be sure that they're doing these things. Remember at the very beginning, I said that when you enter into an agreement with a purchaser, you establish a fiduciary relationship. So as the fiduciary, you must ensure whoever you choose to administer your pre-needs account on your behalf follows the law. So you should make sure that these things are being done. So continuing on, what happens if we have what's called hits? So what happens when you can verify that an account has been abandoned? So if an account has been abandoned, if it's irrevocable, you have to send the funds to the local DSS office in the county where the decedent resided. If it's revocable, then you have to send the money to the New York State Comptroller's office. Again, this is not a situation where it's at need and you're now using the funds and there's amounts left over and it's revocable that's going to go to the estate or the family or the purchaser. This is a situation where funds are in an account, someone's been dead most likely for 3 or more years, and you've now found that this money has been abandoned, and the state's going to basically take it either at the state level or at the county level. So this top half I just talked about is situations where you find out that person's died, there were services, and the funeral director's already been paid in full for the services that were provided. In a situation where the funeral director has not been paid in full, then you pay the funeral director first, and if there's money left over, then you send it either again to the county DSS office or the comptroller's office based on the type of agreement it is. All right, so that was abandoned. So now you have to talk about dormant accounts. So actually, let me just back up 1 second, because that top line is more on abandoned. So if the administrator is taking those reasonable efforts to try to find out if a funeral director has been paid or not, and you can't figure out who the funeral director was who provided the services, so you can't find out if they've been paid or not, then all the funds just get transferred to the comptroller or DSS office. So you have to determine how long the account's been sitting there. After death, if it's been past the triggering time, you're supposed to have your administrator take reasonable efforts to see if a funeral director was paid or not. If they were not, you pay them. If they and you send excess, if there is any, over to the county or state. If they have been paid already, then you just take the funds in the account and send it over to the county or state. So that's abandoned. Dormant accounts occur when the administrator cannot reasonably determine a proper address for the beneficiary, resulting in annual statements being returned as undeliverable. Now, that's not just once or twice. How many times does it have to happen, and in what circumstances for it to be deemed dormant? This might seem a little hokey or weird, but I think it's just intended to be a situation to really make sure that this is a dormant account and that there's nobody around. So the circumstances in which it would be deemed dormant are: you have not for 15 years been able to figure out the proper address, and the person, the beneficiary who it was for, would be at least 115 years old. If those conditions are met, then the dormant funds are sent again to the county DSS or comptroller's offices. And the last section of the GBL that we'll cover, which is the last section of the law, is the annual audit requirements. This is the most recent amendment to the general business law, and that is requiring all administrators of Preneed accounts to conduct annual audits. This is really, I say administrators, meaning the trust administrators. Financial institutions are already heavily regulated and have to do annual audits and are examined by their supervisors and regulators, so they're already covered. So these are the administrators. The requirements are it has to be an audit conducted by a certified public accountant who's licensed in New York State. That audit must be completed within 120 days at the end of the calendar year. The auditor must do certain things to make sure that they're doing the proper type of audit. And they have to verify that the administrator has signed copies of the agreement for each account. They're not going to go through every single account. They're going to take a representative sample and prove it that way. And they also have to make sure that appropriate income tax reports have been sent for each account owner, again, through a representative sample. They have to verify that the investment of all funds for the agreement's compliance with this section, meaning, again, your proper investment vehicles are being used. They also have to make sure that the earnings on the investments are being properly applied to each account. Again, that goes back to what I said about they're credited to the account at least monthly. So that should be showing up and put into each consumer's account. Any interest earned put into the consumer's account on a monthly basis at minimum. And then they have to express an opinion that they feel that the statements that the administrator has fairly represent the financial condition of all the funds and make sure that all the financial information is accurate. And then any yield that is credited to the account is also accurate. So that covers the big section, or the big section of law that deals with the main section that deals with pre-need accounts. I mentioned there were a couple of others, so I'm just going to run through them. The first is section of the Public Health Law 3442, which deals with pre-need reporting requirements. Really what this does, it creates the connection between the two different laws. The general business law is overseen by the Department of State. The public health law is seen by the Department of Health. And that gives the department some oversight of pre-need business. They have chosen to allow pre-needs to generally be oversight of pre-needs to generally be conducted by the Department of State, but there are some aspects that they have control over. So under this section of law, it basically says a funeral director receiving pre-need funds must comply with the general business law. They have to provide a pre-need statement describing the services and merchandise, and they have to maintain those records for 4 years. It also goes on to say that only registered firms may receive pre-need money from consumers, and that you have the same notice requirements that we went through already for the general business law. So as I said, nothing new, generally just making sure there's a connection between public health law and the general business law. Another section that deals with oversight from the Department of Health side is 3450 of the Public Health Law, which deals with suspension and revocation. So when can you get in trouble under this? This is when you can potentially have your license suspended or revoked for committing any of these acts, which would be practicing fraud, deceit, or misrepresentation, committing any act of misconduct, failing to comply with the GBL requirements to keep the funds on deposit pending use or repayment, and then some conditions there. Only if the funeral firm has repeated violations, fail to deposit the money, keep the money on deposit, don't meet your compliance obligations, fail to make refunds, all the stuff that was covered in the general business law. They repeated here just to make it crystal clear that the Bureau and the Department of Health has enforcement action and can take action against someone's license. And then the regulations, which really get into more details of a law than the law does. In this case, it was Health Regulation 7712, which is the misconduct section. So this is when misconduct can result on pre-need agreements and could result in disciplinary action. And the ones here are failing to comply with law, rules, and regulations relating to funeral directing, exercising undue influence on, misleading, or misrepresenting to a customer the sale of services or merchandise. Those first two clearly can apply to at-need as well as pre-need. Making or filing a false report. So we talked about it in terms of pre-need. You have to keep all these records of where the money is, the statements that you're providing to consumers. If you fail to file a false report or you say I did it and you didn't, then you could be brought up on action there. And there are restrictions as to whether you can or how you can procure funeral patronage, meaning going after consumers to have them work with your funeral firm. So if you attempt to procure or solicit funeral patronage through the use of door-to-door or telephone solicitation, that is impermissible. Obviously, since they're limiting procuring or soliciting as a violation if you do it in those methods, door-to-door or telephone, other methods of solicitation are permissible. All right, well, that wraps up the provisions we were going to cover. So what I'm going to do is I'm going to see how many of you are paying attention. If you've been on my webinars before, you know I kind of like to do some Q&A just as another way to reinforce what we were talking about. So I have about 12 questions we're going to run through. I will put the question up, ask it, or read it, and I'll give you a second just to think about it and see if anything I said made sense and if you can recall it. So first is, when is a pre-need account deemed abandoned? So if the decedent or the beneficiary has been deceased for 3 or more years, generally, then you have an abandoned account. How many days do you have to deposit money received for a pre-need account? You must deposit those funds in an interest-bearing account within 10 business days of receipt. Are there any special requirements for pre-need promotional literature and advertisements? Yes. So any literature or advertisements that deal with the irrevocable agreements must contain that disclosure I mentioned early on. So if you're going to just put out pre-need in general and it's possible that someone's coming in and will want to open an account that's irrevocable, every advertisement you have that's out there or literature you put out there that talks about pre-funding and pre-arranging, where it's you should have this language explaining that an irrevocable account would be to be established in these circumstances. May a funeral home charge a fee for making pre-arrangements, whether pre-funded or not? I'm sorry, may a funeral home charge the consumer a fee in connection with a pre-funded pre-need agreement? No. So again, going back to the general business law, that provision in there that I went through that says a funeral director may not receive any compensation in connection with the planning for a pre-funded pre-need agreement. So if you are working with somebody, you can receive an administrative fee, or the administrator can, but you cannot have a fee associated with planning for a pre-need agreement. How quickly must the consumer's pre-need funds be returned once a request is made? So the law's language officially is upon demand, but through practice, it's been interpreted to mean within 10 days of the request. In the case of a funeral home sale, which party is required by law to send notice to the consumers who have pre-need accounts with that funeral home? The new owner, the former owner, or both? So both parties have that obligation, but as I mentioned, it can be one joint letter that is issued to the consumer. Who on this list is not considered a family member for purposes of opening an irrevocable pre-need trust agreement? The cousins. Cousins are not. Spouse, child, stepchild, sibling, parent are all considered family members that the purchaser can open an irrevocable account for. How long are you required to retain copies of agreements after performing services? 4 years. If there's anything you remember on this one, the easiest one is probably that, 4 years for anything you're holding on to. What is an alternate person? The alternate person is the person not living at the same address as the purchaser, who the purchaser selects to receive notifications in the event that that purchaser cannot be contacted. Again, the purchaser can choose to decline naming an alternate person, but you have to make it available. Where do the abandoned funds go if the funeral director has been paid in full? Two options. If it's irrevocable, to the DSS office in the county where the person resided at their death. If revocable, to the New York State Comptroller's office. Can funeral arrangements in a pre-need agreement be changed? Yes, so the purchaser may make changes on a pre-need basis. However, just remember that if it's an irrevocable agreement, the changes must be of equal or lesser value. And our last question, are funeral homes allowed to promote pre-need business through direct mailings? Yes, and I just mentioned under the misconduct provision, door-to-door and telephone solicitations are not prohibited. That is under the health regulation. So hopefully I was able to cover this in a way that was understandable for you all, but that covers what we wanted to go through with you all today, and I'm happy now to try to answer any questions you might have. So Kelly, I'll turn it back over to you in case we have some questions.
And we do. So this goes back to the beginning. Is that transportation during the service or getting them to the service from a destination?
It is the latter. It is transportation for a family member or somebody to get there. So if you wanted to pay for their airfare and other things, you would not be permissible. Anything related to the service itself, including transportation, can be included in the agreement.
How many accounts can one person have?
So generally the rule is you only should have one account per person. There's nothing and that's how we handle it through pre-plan. There's nothing in the law about revocable accounts that says that. So it's possible somebody might have opened multiple. However, the state Medicaid laws are very clear that an individual may only have one irrevocable account. So that is in the law, and we apply that. And I would recommend everybody, applies that to revocable accounts as well.
Okay. So this is a clarification needed. After decedent who prearranged passes, the next of kin wants to change the disposition of the pre-need. For example, from a traditional funeral to a direct cremation or vice versa. Does the next of kin have that ability to change the prearrangement wishes of the deceased?
So interesting. So that's not really a pre-need, that's not addressing the pre-need law. Now you're going back to when we do our normal final disposition discussions and go through that. So unless there has been a stated desire to change what is put in the pre-need by the decedent prior to their death that's known, the person in charge or in control of disposition is required under the law to carry out the known last wishes of the individual. So if what's in the pre-need is still what the person would have wanted, then the law says that the agent in control or the person in control must follow their wishes, and they would not have the ability to change to something else. That is a protection to ensure that in the case of a revocable agreement, if I had set up a revocable and I had all these services and it was going to be, I'll call it elaborate just for lack of a better word, and it was going to cost $15,000, and then a family member comes in and realizes they can do a direct whatever and cut it down to 3 and they can pocket $12,000, they might try to do that. And that's the intention of the law, is to prevent something like that from happening.
Okay. Concerning portability in New York State, the purchaser or the next of kin has the ability to change funeral homes at any given time?
Yes, so portability is a big factor. So so at need, the purchaser can, and if the purchaser's passed, then at need, the next of kin can change the funeral home. So yes, that is something that can happen at any time.
Okay, and then second part of the question, what is considered a reasonable, and which you did speak of, but what is considered a reasonable amount of time when money is to be transferred if notified in writing?
Transferred meaning if it's refunded, then it would be, again, it's supposed to be under the law upon demand, but it's been interpreted to be reasonable if it's done within 10 business days.
Okay, and you spoke of that master list of deaths. Where can we find that?
I believe there is this is something I know pre-plan has to subscribe to get access to it. It's a federal agency. It might be a company that is subcontracted for by the IRS. I will have to go and just double check. I don't recall the exact name, or maybe I can try to Google that while we're having this conversation. But if I can't find it, we will make sure that we get it out to you guys.
If all monies for pre-needs are in a single interest-bearing account and a beneficiary wanted a refund, how would you determine the amount to refund them?
I'm sorry, can you just say that? I'm sorry, can you just say that one more time?
If all the money for a pre-need is in a single interest-bearing account and the beneficiary wanted a refund, how would you determine the amount to refund them?
So I think that might mean the question might be being asked is you've commingled all your pre-need accounts into one account, and now you have an individual who wants a refund. How would you know how much among the total that's on deposit to refund them? That should be pretty easy to do in the sense that you know from the agreement how much they funded. Interest being earned is supposed to be accrued daily and credited to the account monthly. So when I say credited monthly, if you've commingled all your funds and you have one fund, I don't mean it's credited to your overall account. I mean it's credited to each individual's account through your financial institution or your trust administrator. So at the day that person has actually, the day that person made that request, you would have in their account known already credited the full month up to last month. So say they tie on the 10th of May. So all interest earned from the date it opened through April of that year is already posted to their account. And then there's 10 days of interest that was accrued but not posted yet, which would be put into the account by the financial institution or the administrator before that amount is refunded. So that's how they would determine that. That should all be done that way.
Okay.
And Kelly,
just one quick.
I have the answer for the death master file. It's actually through the Social Security Administration, and it is like a contractor through them. It's the National Technical Information Service who distributes it. It's done online, and it's something that you would be able to go through the Social Security Administration. If you go through them, that's how you would be able to get a copy of it. I do not know if that is something that requires a subscription or not, but that's the entity that would have that information.
Okay. If a person moves a paid in full pre-plan agreement from one funeral firm to another, is there any payment one funeral firm must pay to the other funeral firm?
No. None at all.
Okay. Can a reception be provided for Can a reception be provided for both revocable and irrevocable accounts, or just one or the other, or neither?
So if
like
a
a reception for food afterwards.
Yeah, I think if everything was accounted for during the pre-arrangement and selection process, then it could be done. If it was an irrevocable agreement, then you cannot add new services or change something to make it of higher value. So if it was an irrevocable and not included in the first or at the time it was established, or you went from a reception of blank to a reception that includes A and B, and now you wanted to do a reception that includes A, B, C, and D, you can't add C and D to the irrevocable agreement.
Can a spouse be a domestic partner in the way of spending down for Medicaid eligibility?
I am not 100% sure of the Medicaid law and how they write it, but domestic partnerships are legal in New York and treated for the most part on equal basis as spouse. So my guess is that a domestic partner would be treated the same as a spouse, just under the way the state has operated with regard to everything else, including health benefits and insurance products. But I don't know if I can't say with 100% certainty that that's the case.
If a family member decides to change the decedent's prearrangement wishes after death, how do you enforce the decedent's wishes legally?
So what we have told our funeral directors in the past, and we've given them a section of law that specifically says that it's the responsibility of the agent to ensure that they carry out the wishes of the decedent. Then we give that to the funeral director. They show it to the person in control, and the funeral we recommend the funeral director say, "I'm sorry, my hands are tied. The law requires me to I'm required to follow the law, and the law says that you need to follow the decedent's wishes. If you have evidence that the decedent has changed their wishes, I can take it, but I can't proceed unless we go with what was originally decided. You show proof, or I get a court order or other legal document saying it should be changed." There have been court cases where not following the decedent's wishes have come back and been ruled against the person who changed it, and they've tried to bring the funeral director in on the liability related to that. So we always advise what I just said because of that.
When you guarantee the price, we are able to keep the interest plus the principal unless it is more than our current prices, correct?
When you guarantee the price, we can keep, say that again?
The interest plus principal.
Principal?
Unless it is more than our current prices.
Correct. If it's guaranteed and the money's there to cover the guaranteed price, then you would get paid in full for the price that you guaranteed. If there's any money left over, it would either get rebated back or refunded back to the estate or the purchaser if it was the beneficiary, if the purchaser's still alive and it was for somebody else. Or it would, if there's an overage at that point, it would go back, if it was irrevocable, to the county DSS office.
Okay. Can you speak to sending the pre-planned pre-need to a funeral home outside of New York State?
So the individual consumer can transfer their funds out of state and choose a different funeral home. The funds are the only thing that is addressed by the law that can go. If the individual consumer So the funeral home outside of New York isn't obligated to accept the pre-need or pre-plan agreement. They might have their own laws and their own rules there. So the consumer might have to sign a new agreement with the funeral home from whatever state that they're moving the funds to, based on the way the law is written. However, the funds themselves can be moved from New York to another state and deposited in a pre-need, pre-funded account in that state. But the funds being portable and the agreement needing to be accepted are two separate things, and there is no legal obligation for the other state to accept a New York contract, because the contract laws and the laws for pre-need and pre-funding may be different in the other state.
Okay, that is the end of our questions. One more just popped up. Two more just popped up. Okay, so please discuss how at-need changes made to a revocable guaranteed impacts the guarantee protection.
So it will depend on the contract language and what you're guaranteeing. If services are changed or added, that now becomes more expensive. Typically, the language would say that the guarantee is only guaranteed for the services and items selected, and if the amount is paid in full at the time of need. So two kind of triggering things. One is keeping to what was selected and not adding things that are now more expensive, because that kind of wasn't part of the original deal and agreement. And the second part is making sure that if you're saying you're going to guarantee doing A through L for $5,000 and they only deposit $2,000, and at the time at need comes around, there's still only $2,000, that voids the guarantee as well.
Okay, and can a cemetery set up a pre-need account in a financial institution?
Under the law, it says only a registered firm may accept pre-need monies for funeral service. Now, if a cemetery is going to accept pre-need funds for purposes of what services they provide, that's permissible that I'm aware of. But they can't open a pre-need for funeral services.
Okay, so that might be it. So I'll just take a moment and thank everyone for being on this webinar today. Again, we ask for your patience as we get these credits posted to your portal and get those letters out, knowing you are all waiting for this last credit to get your paperwork into the Bureau. Mike, thank you so much for your time and for your information. And I will just let everyone know, if you ever have any questions about anything, pre-need law or otherwise, you can always give Mike or I a call here at the office. We either know the answer or we will find it out. I hope everyone has a great afternoon, and thank you again so much.
Thank you.